Well, hello there. Welcome back to another episode of the wacky world of Delete Lawz. I didn't think I'd be back so soon, but here he is rattling his sabers about another lawsuit, this time against Blue Bacon. So, as I'm sure most of you are aware, if you follow Delete Lawz, he was recently slapped with a restraining order or protection order, whatever it's called in Washington, by Blue Bacon. In order for that to go into effect, Blue Bacon needs to have him served, which he is attempting to do. Delete Lawz is clearly unhappy about that. And he sent an email to Blue Bacon informing him that he's unhappy about that. And Blue Bacon has put that email on his community tab on YouTube. Now, and I'm going to read that for you. Unfortunately, the way it was posted, it's tiny and the whole thing isn't showing up on my computer. So, being the professional that I am, I'll read it from my phone, which is tiny, so bear with me. He starts, Mr. Piratini, this is an official notice of intent to sue. The lawsuit will be filed early next week. See January 17, 18, 19. It has been brought to my attention that you have taken some sort of legal action against me. I only know this because my family called me and told me that a process server showed up at their house. Which we know is a lie because he's talked about this on video. At least I'm like 90% sure. Plus, he freaks out about Merb's videos, and Merb has gone hard making fun of this on both sides. But continuing, Michael, you have 48 hours to retract any legal action against me. And if a process server comes to my house or to any member of my family's house, negotiations are over, and I will file the federal lawsuit against you. Whatever legal action you took was accompanied by lies and deception on your part. It will all come out in federal court because I'm suing you for over $75,000. Let me make it perfectly clear. If a process server goes to my house or any member of my family's home after I send you this email, I will file a lawsuit against you, skipping stipulations or negotiations. And once I file that lawsuit, there's no going back. The courts just don't blindly enforce fraud. The courts take a look at the content of each situation. You are a fraud. It's an additional category in my federal lawsuit against you. I did not publish this publicly because I want to get the fuck away from you, and I don't want anything to do with you. We are done. I have no idea what legal action you have claimed against me. However, I've already started writing the lawsuit I'll be filing against you. If a process server shows up to my house or any member of my family, you'll be sued. Michael, the courts will not shine a favorable light on you for abusing, lying, and manipulating the court. There are plenty of videos of you inviting me to find you. This is so hard to read at like 3-point font. Stipulations that must be met before we can part amicably. 1. Remove every single video you've ever made about me. You have until Monday morning, and if the first stipulation is not met, I filed a lawsuit and we begin. 2. Retract any legal action you have taken, and you can start by canceling any process server. If the process server shows up to my house, stipulations are off and I sue. 3. Mutual no contact agreement. I will not mention you and you will not mention me. I've got you dead to rights. You will lose the lawsuit. Moreover, it will cost you a lot of money to defend what I'm about to do to you in court. You will have to pay. It's a lot of money, Michael. My stipulations are clear. I'm done playing with you. If you'd like to go to federal court, don't meet my stipulations. I will file on Monday or Tuesday. You are a lying piece of shit, and the judge is going to find out that you lied to file any legal action against me. It won't go well for you. Further, what this will do to you financially will be immeasurable in comparison to the choice of simply mutually disengaging. I already took down any videos about you. Tell your audience you have had a change of heart and you want to focus on what you do best. IDGAF. I do know I'm done. I've had enough of you and you're the possessive you're bullshit, and I'm ready to put 200 hours into stomping your life to bits through court. Ask Kate what she thinks about all day, every day. Ask Kate where all of her money and time goes. I'm filing a contempt charge against her tomorrow. She must respond to it, Michael, or I will win the motion, meaning she has to pay her attorney. I wrote my motion with friends. You got $80,000 in donos? You want to spend the next 2 years with me constantly filing against you? Michael, we've already seen that when I turn on face you, you are no match for me. And I'm mad now. I was always annoyed. I'm ready to dedicate 200 hours to you and ruin you financially for defamation, slander, libel, and fraud. You think I'm investing in future properties? You're not. You think you're investing in future properties? You're not. You think you're spending your money on anything in your studio? You're not. Your next 48 hours dictate where your wallet and time goes for a very long time. Factor in that I'm going to win. Because you're such a piece of shit and have made so many videos about me, anybody who is objective can see that you're a grifting piece of shit. This is between me and you right now. If you publicize it, I won't enter mediation with you for at least 1 year. That will be an expensive year. You can publicize this letter. You can skip the stipulations. Cool. I'll find out about your video because somebody will tell me, and you will be served this week. I would consider the criminal charges you may have to deal with when I turn and face you and go after you in Washington State for fraud, abuse of the court. Please don't respond to my email. I won't read it. I'll only delete it. I don't give a shit about you, dude. I don't give a shit how you respond in words. I'll know by Monday if the videos are down or not. Don't worry, Kate's will come down too. I'm suing her in California too. This isn't over by a long ways. I will never stop once I start until I win. Period. I understand. I've said something similar in the past. The difference is you sent people to my family's home. Kate sent people to my house in Denver. Her trolls attacked my fight camp. Got my Airbnb canceled. It was too far for me. She is 80K in now. Me and you, online. We're done, one way or the other. The games end, and now it gets financially real for you. Even if you publicize my letter and try to make fun of me, I will never talk about you, probably. I will just file motion after motion after motion until I win. And then I'll see you in state court. I give you my word. I will never mention this letter to anybody else. Monday, 9 a.m. All bets are off after that. This ends Monday, or we end it in court. Sincerely, Jose M. De Castro. Whew. Well, that was interesting. And I think in analyzing it, the first place we need to go is, I guess I should have clicked through so you could see the partial pages. But on the second frame of that, let me pull it up again, where he says, ask Kate what she thinks about all day, every day. Ask Kate where her money and time goes. I'm filing a contempt charge against her tomorrow. She must respond to it, Michael, or I win the motion, meaning she has to pay her attorney. So I realize Blue Bacon and Kate aren't necessarily the best of friends. Kate has derided him for this protection order, restraining order. But they do need to take into account the old adage, the enemy of my enemy is my friend. Kate and Josh Abrams are not the best of friends either, but they're able to put aside their differences to at least cooperate. And their attorneys, who formerly worked at the same firm anyway, Benjamin Wish and Joshua Garrick, have obviously collaborated to some extent on this lawsuit. We've seen it in motions filed that they've shared the motions between each other before filing. And I think what needs to happen is Blue Bacon needs to send this email to Kate, but he also, in my opinion, should write an affidavit, something to the effect of, this is a true and correct copy of the email I received from this email address, which is a known email address used by Jose de Castro. And he talked about his lawsuit with Kate Peter in that email. Because we just discussed in my last video this contempt motion. And I said something to the effect of, if I'm defending this contempt motion, I'm talking about he's a tyrant and he's trying to silence my criticism of him through the power of this court. Well, we've already seen in previous motions, both Benjamin Wish and Joshua Garrick use the quote from the video saying, I don't care if I win or lose. I just want to cost them money. I want to cost them lawyer fees, blah, blah, blah. Well, here he sent that to Blue Bacon, meaning she has to pay her attorney. And I don't know that she does, because he says she has to respond to it or I win. Well, not so fast, because we've got to get a little legal analysis in this video. So here's our old friend, Federal Rule of Civil Procedure, Rule 12. So 12A is the time to serve a responsive pleading. So in general, unless another time is specified by this rule or a federal statute, the time for serving a responsive pleading is as followed. So A1A is when an answer must be served. A1B is when a counterclaim or an answer to a counterclaim or cross-claim needs to be served or done. Whatever. I can't talk. And then C, a party must serve a reply to an answer within 21 days after being served. But those are filings that absolutely require a responsive pleading. Remember yesterday we were looking at Rule 15, and it talked about the time to serve a responsive pleading, or the time to file if a responsive pleading is necessary, if it's required. So we already know not all pleadings require a responsive pleading. And here on A4, we have effect of a motion. Unless the court sets a different time, serving a motion under this rule alter these periods as follows. If the court denies the motion or postpones its disposition until trial, the responsive pleading must be served within 14 days after notice of the court's action. Or if the court grants a motion for a more definitive statement, the responsive pleading must be served within 14 days. Yeah. That wasn't, I think, what I was after. But either way, I don't think this is a pleading where responsive pleading is required. And as evidence, real world evidence, let's go back to the docket in DeCastro versus Abrams. And we have docket number 78 from December 1st, which reads, plaintiff's motion for contempt, ECF number 61, and defendant Peters' cross motion for contempt, or plaintiff's motion was ECF 61, Peters' motion for cross motion for contempt was ECF 71, are both denied. Well, let's see. So we have 61, emergency motion for contempt by Jose Maria de Castro. 71, opposition re-emergency motion for contempt filed by Kate Peter, which was an opposition and cross motion for contempt. But 72 is affidavit from Kate. 73 is another nunc pro tunc. 74 is the judge losing her patience over the nunc pro tuncs. Or is that nuncs pro tunc? I don't know. 75, a motion for extended time to file an answer filed by Josh. 76, motion for leave to file a supplemental complaint. 77, order granting leave to file the second amended complaint. And then 78, contempt motions denied. So Delete Lawz never responded to Kate's motion for contempt. It was denied. Almost as if no responsive pleading was necessary. So clearly that means Delete Lawz lost that motion because he didn't respond. I mean, that's his logic in his letter to Blue Bacon. But, oh no, they're both denied. Wow. So, if I'm Kate, though, assuming the court doesn't deny it before I respond, I'm going to respond anyway. Because I want to keep hammering it home that he's filing these motions for nefarious means. He's not filing them in good faith. He's trying to just cost her money responding. At some point, like I said in yesterday's video, at some point, just like the judge has officially lost her patience with his endless complaints, the amended complaints or supplemental complaints or amended supplemental complaints or however he styles them. At some point, if he keeps filing these obviously frivolous motions for contempt, which number one, Rule 11, if you remember, we discussed that way back on like the first motion for contempt. Rule 11, before you can even go to the court asking for Rule 11 sanctions, you've got to give the other party notice and an opportunity to fix. Now, I'm not Kate. I don't communicate with Kate. He might have. I highly doubt it. So he's not following the procedure, which, as we remember, even though he's pro se, he still must follow procedure. His filings can be construed liberally. He's held to procedure the same as I am. But at some point, like I said yesterday, the judge is going to lose her patience, and she's going to play that Uno reverse card, and she's going to hit him with costs for responding to these frivolous motions. And that's why Kate needs this email, and she needs, or at least it would be very helpful as an exhibit filed at the end of her response motion, an affidavit from Blue Bacon, because that just tips the scales more in her favor to get the judge to play that Uno reverse card. So it's important. Now, I should have pulled this up earlier, but he's a fraud. He says, I'm going to sue Blue Bacon for fraud. Well, he's not going to. Because let's look at for a civil fraud case. So this is on lylesparker.com, which is an attorney's website, attorneys and counselors at law, which is fine. So there's 4 elements of fraud. Civil fraud. Well, this is found in Texas legislation. It's going to be the same everywhere. So number 1, there was a material representation made that was false. Well, he's going to have to prove that Blue Bacon falsely stated he was concerned for his safety based on Delete Lawz actions. Well, how he can objectively prove that Blue Bacon's subjective fear was false, I don't know. But he'd have to do that to prove fraud. Number 2, the person who made the representation knew the representation was false or made it recklessly as a positive assertion without any knowledge of its truth. So that's the level of intent. In crime, that would be the mens rea. So number 1 would be the actus reus. Number 2, the mens rea. 3, the person who made the representation intended to induce another to act upon the representation. And I'll come back to that. And 4, the person who to whom the material representation was made actually and justifiably relied on the representation which caused the injury. Well, this is going to be a major problem for Delete Lawz, because like I said, we'll go back to 3. The person who made the representation intended to induce another to act upon the representation. So who, assuming this was false, which is going to be impossible to prove anyway, since it's Blue Bacon's subjective feelings of his personal safety, who did Blue Bacon induce to act upon that misrepresentation? The Washington State Court judge. So if he committed fraud, it was fraud upon the state court judge in Washington, not on Delete Lawz. So Delete Lawz does not have a cause of action for fraud. It's ridiculous. It's absolutely and completely ridiculous. So finally, let's get back to the threats of the lawsuit itself. Well, number 1, he says he's going to sue if Blue Bacon continues trying to serve this protection order on him. Well, that's not a valid cause of action. I mean, honestly, if you could sue someone for serving a lawsuit on you or serving a protective order on you or whatever, then the courts would never work. I mean, and furthermore, how, if it's illegal to serve process on someone, how is Delete Lawz going to serve Blue Bacon with his federal lawsuit if that gives Blue Bacon a reason to sue him? It doesn't make any sense. It's asinine. And I mean, the funny thing here is, let's go back to the video we discussed yesterday, which brought up the contempt motion. So the first part of the video, Kate was discussing Delete Lawz and Torture Cuff's website. After that, she controversially had Long Island Audits on, and they discussed Mark Stout, who I don't even know what his current YouTube channel is. I think it's Frauditors Exposed or something like that. It used to be Legalized Drugs. So here's the funny thing. It completely mirrors this situation, because apparently I don't follow either of them. I didn't care for Mark Stout when he was Legalized Drugs suing Schrodinger's cat. The person hasn't changed, even if his viewpoints have. So I didn't watch him as Legalized Drugs. I don't watch him now. But apparently he's suing Sean Paul Reyes, Long Island Audits, because Reyes went to Stout's house to act as a process server for someone else to sue him. Now, I don't know if this was a federal lawsuit or Virginia state court lawsuit. Because, like I said, I don't follow either of them. And some of the comments said, well, that was their first mistake. They should have had a proper process server, a constable, sheriff's deputy, whatever. Well, that's possible with Virginia state courts. But if it's federal court, unless there's a local rule to the contrary, it's anyone can serve. It's so service. A summons must be served with a copy of the complaint. The plaintiff is responsible for having the summons and complaint served within the time allowed by Rule 4M and must furnish the necessary copies to the person who makes service. By whom? Any person who is at least 18 years old and not a party may serve a summons and complaint. That's the federal rules. So anyone can serve it. Now, Blue Bacon, working for a private investigating company, has talked about he's using his resources. I'm sure he's used a process server, like a licensed process server for this. And what am I basing that on? Nothing but his past comments from when he first filed. And this was Rule 4 of the Federal Rules of Civil Procedure, summons. So Stout sued Reyes for harassment or trespassing or something. I don't care, because he served him. But let's think back, because a year and a half ago, roughly, or a year and a quarter, Stout served Overby, Schrodinger's cat. And who did Stout use to serve Schrodinger's cat? Was it a licensed process server? Was it a sheriff, a constable? No, it was his sister. But apparently, rules for thee but not for me doesn't just apply to Delete Lawz, to Jose de Castro. It also applies to Mark Stout. Now, I'm not defending Sean Reyes by any means. I think his actions are pretty awful, but it's ridiculous. So finally, let's go back to the email. And I'm not going to look for the exact quote, but basically he said, if you share this email, if you publicize it, I'm going to sue. No stipulations, nothing. We just sue. So this community post, I like to think, is Blue Bacon's way of paraphrasing our dearly departed late great Schrodinger's cat when he said, "Sue me, bitch." And while I don't want Blue Bacon to get sued, it's a waste of time and money. So for Blue's sake, I don't want him sued. For my sake, other than discussions and comments, I've never spoken to Blue Bacon. I don't personally know him. I'm entertained by his videos. But for my own selfish reasons, I say, sue him, bitch. Because I'm lazy, and this is easy content talking about a moron's lawsuit. So, you this is just double the fun for me. But with that, thanks for joining me. Do all the YouTubey things. One of these days, I'll remember to say that at the beginning, but like, share, subscribe. And I will, I'm sure, see you guys soon for more nonsense and probably other fun things in the very near future. So have a good one. Bye bye.